Thanks so much for joining us again. We're about to begin our second panel of the day, which is titled Life After Students for Fair Admissions versus Harvard. As I'm sure all of you know, that is the landmark Supreme Court case from last year, which banned explicit racial preferences in university admissions, and it seems like might have created just as many problems as it solved in terms of the lay of the land for universities in deciding exactly how or if they're going to comply with the Supreme Court's ruling. I think it's useful to look at the results of that ruling among the many universities that still say explicitly that they are committed to racial balance and even to racial preferences in their admissions despite the policy. For example, look at the changes that Harvard made to its admissions after the ruling came down. In its application, it now requires not one, but 5 personal essays from every applicant describing how they are going to contribute to a diverse student body. I think that everyone in this room probably remembers a policy called Don't Ask, Don't Tell. I think with regard to racial preferences, Harvard's policy is we won't ask, but definitely tell. Tell us again and again and again what your racial background is. And so a few things are clear. One is that certain schools will only be dragged into complying with the ruling by litigation. They will take as much space as the law permits them to take in terms of continuing to discriminate on the basis of race, and will only be forced to actually update their policies substantially if there are subsequent rulings that force them to do that. I think even among schools that are trying to comply with the ruling, it's going to take a long time for them to actually implement results and for us to start to see a different racial balance in terms of who's admitted. And for a lot of schools just have very tough choices in terms of figuring out how do we reconcile our values of having a diverse student body with giving preference to merit and making sure that we aren't discriminating against high-achieving students who happen to come from privileged, quote-unquote, racial backgrounds. And so to discuss this issue with me, I have a panel of experts on the topic. First, we have Rick Banks, who is a professor at Stanford Law School and a co-founder of Stanford's Center for Racial Justice. We also have Devin Westhill, who is president and general counsel of the Center for Equal Opportunity, where he focuses on civil rights law and issues regarding civil rights. And here we have Renu Mukherjee, who is a Paulson policy analyst at the Manhattan Institute, where she also focuses on education and race and admissions. And so I want to direct my first question to you, Renu. Could you give us a little bit more detail on where things stand a few months after the Students for Fair Admission ruling? What have universities done to comply with it? What have they done particularly to circumvent it among the many schools that we know opposed to the ruling? Do we still see discrimination happening in admissions?
So what's really interesting is that half or so of the schools right now are implementing essays, actually most of them are, in which they're, as you mentioned, Mene, are sort of asking and prompting students to say what their race or ethnicity is. And this is a phenomena amongst the elite colleges and universities. What's also interesting is that within the last few weeks, we've seen in the news that Dartmouth, other institutions are bringing back standardized testing. So prior to the decision, it appeared as though one way in which schools were going to defy the ruling was because there are racial disparities in the SAT and the ACT that have existed for quite some time, was a move away from standardized testing. Schools have now seen that that has had horrendous effects in terms of freshman year GPA and graduation rate, and are bringing tests back. So to that extent, you could say that they are perhaps complying with the ruling. But the main way in which they're trying to get around it, and again, the most elite institutions, are through essay questions. A few minutes after the decision in SFFA came down, Harvard released a statement via email to its community citing the line from Chief Justice John Roberts' opinion, in which he stated that nothing in this opinion should prohibit students from describing how race has impacted their lives in terms of inspiration, discrimination, or otherwise. And Harvard said in that email, we will certainly comply with this. Of course, that ignores the immediate next sentence of the email, the opinion, which is you cannot accomplish through application essays, for example, the scheme we have held to be unconstitutional today. So no schools paid attention to that. So of course, schools are going to try to continue granting racial preferences through essays. I think one thing that is worth bringing up, it's not just these university administrators and admissions officials that are thinking of these questions themselves. I think this has been absent from the conversation over the last year or so, which is that these schools are getting direction from education consulting firms and, surprisingly, College Board, which is known most famously for its development and administration of the SAT and advanced placement exams. Over the last several months, College Board has been hosting webinars, information sessions, gatherings for college counselors in high schools and admissions officers, in which they are advising these education administrators to prompt Black students to write their essays about victimhood. And the last thing I'll say on this is that the New York Times in January interviewed dozens of high school students and their parents about what it was like to apply to college this fall. And all but one of the students interviewed said, "I originally did not write my essay about race, but my college counselor told me I should write about race and how it has made me a victim, and that's how I'm going to get into an elite college." And so it's not just these administrators coming up with this, it's really being directed in a top-down method.
Mm-hmm. Well, it's interesting what you described about the immediate response of the universities being to let their stakeholders know exactly how much space they had left over to continue to try to reconstruct the old scheme of racial discrimination. And that makes me wonder, Devin, what can you describe about the exact legal contours of the ruling as you understand them? Because not long after it was handed down, we did see the Supreme Court decline to hear a case involving Thomas Jefferson High School in Virginia, in which the Fourth Circuit ruled that a very explicit new standard that they had made to enable more racial preferences in their admissions that had decreased the number of Asians who were admitted and increased the number of Blacks. The Supreme Court declined to hear this case, which means that they must be allowing a certain amount of space for different jurisdictions to describe how they're going to comply. They're not necessarily trying to enforce an extremely strict standard about what it means to comply with the ruling. Can you describe where the legal landscape is today, and also any other observations you have about where things stand?
Sure, yeah, and I should say I'm really happy to be back here at the old PARKLAND Conference 2, I guess. I had the opportunity to talk about this case and about affirmative action, race preferences, and so forth at the original old PARKLAND Conference. And there are some things that I talked about then I want to revive in this conversation today, if I can. But first and foremost, look, I think at the end of the day, what the Supreme Court did, and it's important for the Supreme Court to, as narrowly as possible, sort of rule on these things, right? You don't want to open up a terrible can of worms and putting out an opinion. What the court did was prohibit the overt use of race in college admissions. That's what I think that it did. Now, I would have preferred that the court overturn some of its precedent in this space, particularly the 2003 Grutter case that basically solidified the diversity rationale for race preferential treatment. It didn't do that. And so there's a question about how far the court left open the door to continue to have some sort of race-conscious admissions programs. And you suggested the TJ case, which I think you summed up just fine. TJ is a very high-level high school in Northern Virginia that had rejiggered its admissions program. This was before the SFFA decision came down last year, to ensure that they decreased the number of Asian Americans that were being admitted into their high school, out of middle school, and to increase more preferred races, Black and Hispanic students in the area. They didn't do that overtly. They didn't put race into the consideration overtly, but they did it in such a way that it was clear their end goal was to racially gerrymander their classes. They were wildly successful with it. And as Mene just suggested, the court declined to take up the case, suing them over that. the Center for Equal Opportunity, the organization that I run, filed an amicus brief in that case arguing that that too is illegal, right? If your goal is to racially discriminate, even if you're not doing it overtly, that is against the law. That violates the Equal Protection Clause of the 14th Amendment. It violates very clearly the letter of the law of a number of civil rights statutes, and that's what this school was doing. I'm very happy to say, despite the fact that the court chose not to take that case up, and we can speculate as to why that is the case, but Justices Alito and Justice Thomas dissented from that denial, saying this is really the Fourth Circuit here on where the court that last took the case got it comically wrong. Right, this is not the way the law works. It's certainly not the way the law works after SFFA, and we should have taken this case. There are other cases in the pipeline right now that are going to be testing the boundaries of SFFA out of New England and some other places, the Pacific Legal Foundation that my organization works pretty closely with, and looking at these sorts of matters are bringing those cases as well. I suspect if we get a circuit split on this issue, whether or not you can basically still discriminate, but just not as clearly, as overtly, that the Supreme Court might be interested in taking this up and saying what I think the law is, which is you can't do that. That is illegal.
And I think that as schools are still awaiting subsequent rulings that are going to further define exactly where the limits are on what they can and can't do, they're already thinking about what is explicitly in bounds in terms of what we can do, A, to make sure that we aren't explicitly discriminating against students in our admissions policies, but B, if we do have diversity as a value, what are we clearly allowed to do that might give us a better racial balance, that might actually keep us closer to having a well-balanced class without having to discriminate against students from high-achieving backgrounds. And so one of the topics that emerged really right after the ruling was, are schools going to start to curtail their legacy admissions, because that is seen as a policy that tends to disproportionately favor white and wealthier students. And there are other changes that universities can make to their admissions policies toward that same end of how can we make sure that the playing field is level so that we can have a good proportion of Black and Hispanic students without having to actively discriminate against white and Asian students. And so from your vantage point, Rick, I wonder what you think about legacies in particular, and then other things that universities are doing to try to comply with the ruling and figure out their new stance.
These are a lot of issues. How much time do we have?
Thank
you. I'm delighted to be here. Thank you all for being here. This is my first time here. These are a lot of issues which give us a lot to unpack. Let me start off by framing it as a question, which is, while we often assume that we know what discrimination means, we should instead see discrimination, the idea of discrimination, as this, concept that might have very many different meanings, right? So when the court talks about racial discrimination being prohibited or requiring institutions to be colorblind, when you look closely, questions will naturally arise about what precisely that means. And that's where all the fighting is going to be, about what the contours are of this non-discrimination mandate. Legacy preferences are one example where the issue has arisen. Legacy preferences, just to put us all on the same page, refer to preferences that mostly private universities provide to applicants on the basis of a parent or some other family member having attended the university. Legacy preferences are ostensibly and formally non-racial, so they are racially neutral in the sense that everyone who fits into the category is accorded the preference, and race doesn't really, enter into the evaluation of someone's legacy status. But on the other hand, legacy preferences do tend to benefit students who are disproportionately white, because those are that's the population of graduates of most of our elite universities. Legacy preferences were also created about a century or so ago by Ivy League schools in particular, precisely because they wanted to eliminate Jewish students from their student bodies, and they wanted to And they did that by preferring the sons at that time of their graduates, who were almost 100% white. So legacy preferences they're not formally discriminatory. They don't require a school to take account of any individual applicant's race, but they do have a discriminatory impact, if you will, right? I mean, Asian Americans, African Americans, Latinos are all dramatically underrepresented in the pool of legacy applicants. And then they also were enacted precisely because they had this racially discriminatory impact, because they would eliminate Jews from the applicant pool and give priority to white men at the time. So that's the history of legacy preferences. In the Harvard litigation, Students for Fair Admission, it had one ironic or maybe unintended effect, which is that it made legacy preferences much more salient. Right, because part of the during the discovery process of that case, one of the things that became apparent was that legacy preferences were really important. I mean, significant. They contributed to the class in as substantial a way as the race-based affirmative action policies that were under attack. Right, so from the vantage point of the Asian applicants who were the ones filing the lawsuit, and their claim in essence was, and I'm putting this crudely, was we are the highest achieving group in the applicant pool, yet we have the lowest admissions rates. That was their claim. You're trying to keep us out. And they focused on the affirmative action policy as what was keeping them out, right? And they prevailed on that claim, but one is hard not to see that you could also have looked at the legacy preferences as part of what was keeping them out. Right, so after the Supreme Court decided the case, immediately after, in fact, people began to say, if these affirmative action race-based preferences are illegal, what about these legacy preferences? Why are they permitted? And that's the debate we're having right now. And if I could predict, I think legacy preferences are probably on the way out. Every university that has them in the country right now is probably reconsidering them. There has been federal legislation proposed that would prohibit legacy preferences. There's been some state legislation proposed in California, for example, that would also prohibit legacy preferences. And the justification, in short, is that if there's not a justification for race-based affirmative action and we think that's unfair, there's similarly not a justification for legacy preferences, and those are unfair as well, right? So this is just kind of a symmetry kind of approach. My view, just to make it even more controversial and provocative here, is that both of those efforts are misguided for the same reason. The Supreme Court's decision to end affirmative action is misguided for the same reason that legislative efforts to end legacy preferences are misguided. And they both are wrong because they misunderstand what is the source of the greatness of the university system in the United States of America. The reason people from all over the world want their children to come to school in America, and the people from all over the nation want their children to go to the leading schools in America, has to do with the particularity or peculiarity of our system, which is that compared to most any country anywhere, we have given universities extraordinary leeway, autonomy, discretion. We've kind of allowed a market to work in the university system so the universities can work free of government, or not free of government oversight, but within very broad contours, universities have autonomy to do as they will, right? And that's really the secret sauce of the American university system. That's why Oxford and Cambridge and all these other schools who started even before Harvard and the Ivy League, their endowments are just 5, 10, 15% of what they are at the American universities. These American universities have a recipe, a business model, if you will, that has worked really well. And I think we should be very hesitant to interfere, either as a court or as a legislature, in the business model of the university when the universities know best what works for them. And so that's all to say I'm hesitant to think that these efforts to either end legacy admissions or end affirmative action, that this is all going to turn out well. It may be a case of, what's the phrase, killing the goose that has laid the golden egg.
Oh, yeah, I'd love to hear both of you respond to that.
Yeah, so I just wanted to respond to say there is some agreement here. I think that the push right now to potentially end legacy is more complicated than what people, I think by and large, allow in the conversation. I'm concerned. I mean, one of the reasons why there's legacy is because it brings money into the university. And one of my great concerns, which is why my organization is launching right now and sort of an affirmative and positive civil rights agenda in this historic moment that we're in, not just to, although we're doing this as well, to ensure that schools are complying with the new change in the law. But, kids that are otherwise deserving, otherwise academically prepared to go to the elite institutions in this country but can't afford it, may be harmed if legacy is prohibited or is taken out of the calculus in these schools. I'm concerned about that. I find it curious that after 50 years or more of race affirmative action in college admissions, if the goal is to continue to racially balance classes or to have racial diversity within colleges and universities, you might be harming your goal of doing that if you eliminate legacy. Sure, there are going to be more white kids, right, that might get admitted because of legacy, but there are a lot of black and brown kids now, or adults now, who have kids who are applying to these institutions who would get a legacy preference because their parents went there over the course of the last half a century of race preferential treatment. So it's a little bit more complicated, is all I'm saying. And I'll say one additional thing. I think one of the reasons why our colleges and universities, the most elite ones, people from around the country want to attend, is because they have the best and brightest students. They're producing the best papers, research, all of those types of things. And not necessarily because they're the most autonomous or have the least oversight of government and so forth. It's because those are the places people want to learn, where they think they can get the best education. And I think we're really harming that if we think that judging people on their race and getting into those institutions is something that attracts people to those environments. I'm not saying, actually, I'm saying the opposite, that if we have a decrease, which a lot of people are suggesting, in racial diversity and at our most elite institution, we talked a little bit about this over breakfast this morning, that we're not losing something. I think we are actually losing something, and that it is a problem to some extent. I'm just saying that can be made up for. And it ought not to be, certainly not, made up for by divvying people up based on their race.
If I could just respond briefly at this, just to connect this panel to the earlier panel, one of the hallmarks of the American approach, which is different from most other countries, has to do with the balance between private and public institutions, right? In most countries, the premier institutions are the public government-run institutions of higher education. But those institutions pale in comparison to the private institutions of the United States. So there actually is a relation to the fact that we have given private institutions leeway to do what they want to do, and the fact that by most measures we have the greatest university system in the world. There's a connection there. And we might think that there's not a cost to continuing or increasing government micromanagement of those institutions. But the problem there is once the costs become obvious, we will have lost the institutions. So we need to cherish the institutions. We need to try to preserve what makes them great. Part of what has made them great is the ability for them to make decisions, to figure out what goals they're pursuing, how they're pursuing it. We can set some broad parameters, but I do worry now that we're seeing the beginnings of either legislators or judges interfering, making decisions that, as you say, deny the complicated nature of the issues they're trying to address.
Well, I want to go to you here, Renu, and ask, I know that you've done some research on what colleges ideally should do if they're trying to comply with the letter of the law in the ruling, but also want to continue to have a diverse student body, not only in racial terms, but in terms of socioeconomic background and a lot of factors. I know that you have a template set up about what the ideal model to pursue would be, and I'd love to hear you describe that. And particularly, I'd also want to hear if you have any thought on that public-private distinction, because that was one of the issues in the ruling. Are there different burdens on public schools versus private ones in terms of how they're able to use race as a factor? Do you think that should be handled differently by public versus private schools, or that the law applies equally to both?
Sure. So much of the focus in the immediate months after SFFA was schools are going to get around this through essays. And I think that's important to continue focusing on, as well as, are these selective public high schools going to come up with admissions policies that are race neutral in theory, but racially discriminatory in effect? And will colleges adopt these policies? But now I think another interesting question to look at is, in a post-SFFA America, what is the ideal admissions policy? And this has made me interested in, for example, in looking at percentage plans for admissions, a concept that began right here in Texas after the Hopewood decision in 1996. And so how percentage plans have worked historically is that the top 10%, again beginning in the late 90s in Texas, were guaranteed admission to all state public colleges and universities, and the two public Ivies or flagships here in Texas being UT Austin and then Texas A&M. A similar approach was then, and this was passed under a Republican governor. The second state to adopt a similar policy, though they did top 20%, was Florida, also adopted under a Republican governor. This past January, New York Governor Kathy Hochul announced that she had assembled a task force to develop a percentage plan for admissions to the State University of New York, and you have a Democratic governor in a very blue state. So this is gaining traction as a popular admissions policy. So I thought, let's look at the academic, economic literature on what percentage plans accomplish. Do they work in terms of, most education economists that have studied this admission scheme really care about, does it in effect mimic affirmative action? Are you going to get racially diverse and ethnically diverse classes because many high schools in places like Texas and New York are racially segregated? So is it sort of de facto affirmative action? What these studies have found is no, and that's because demographic change is not accounted for. I'm not interested in continuing through means that are sort of, undercover affirmative action, continuing to racially gerrymander entering classes in higher education. That's not what I thought was interesting, and there's a lack in the literature that looks at the question of, do percentage plans help students? Is this a viable race-neutral admissions policy we could have? If you only look at high school GPA, what the literature shows is, over time, test scores in Texas at the two most elite schools have declined amongst percentage plan admittees. The college GPAs are declining. And so, in theory, this is a meritocratic approach, but how can we make it better when we know things like standardized test scores predict not only college success, but future earnings? One way is to somewhat create a composite score in a percentage plan where you do have students not only take the SAT or the ACT, but that factors into the admissions policy. Something that Texas Republicans tried to do a few years after initially passing the top 10% plan was to put sort of curriculum guardrails. You're only eligible if you've completed calculus. That didn't get much headway, but that is something, that states could consider going forward. The Florida plan was most explicit in being very overt in wanting to continue racially sort of gerrymandering classes, which is why they did 20% as opposed to 10 or 5. And that has had it's sort of been quite a disaster, and it hasn't really, been fixed, which is interesting. So I think going forward, more and more states, again, it is pretty bipartisan that you have, Kathy Hochul pointing to Texas and saying, Governor Bush at the time did a great job. You wouldn't expect to hear that nowadays. So this is something that I think, if I shouldn't predict the future, but if I do, more states, both red and blue, are going to look at. But I think in terms of, if you don't just focus on racial diversity, if you actually want to focus on student outcomes and student success, limiting an admissions plan of this sort simply to high school GPA might not be the best avenue. You might want to also bring in exam scores to a certain degree, and also, make sure that students who are eligible to be ranked in the top 10% have completed like 3 years of English already, or have completed pre-calculus, et cetera.
Mm-hmm. And I wonder, as we're hearing about all of these different politicians describe a political approach to setting guardrails on how their state university systems are going to consider admissions, makes me wonder, Devin, about what the role of public policy and public opinion should be in all of this. Because you do see consistently that when it's put on the ballot, racial preferences tend to be very unpopular. And that's true among blue states. In California in 2020, just after all of the George Floyd unrest, progressives put on the ballot there the intention of repealing racial preferences in the University of California system, and that was defeated by a very wide margin. And you saw support for restricting racial preferences even among minority voters as well. I wonder how you think about how universities who are in the position of making some of these decisions, how should they be influenced by the fact that it seems as if the racial preferences have been consistently unpopular, and if that should inform the debate, because obviously it's very separate from the courtroom.
Well, I think it should inform the debate. I will say that California won't take no for an answer. So they have right now a new initiative called ACA 7, where they're essentially, I think, trying to get around that ban that has been in place in California for a long period of time, using race in public contracting, employment, and in education. I've written to every senator in leadership in California saying this is a bad idea and you ought to jettison it, but we'll see what happens with that. Look, I think you're right, Minnie, that the vast majority, every survey, every poll essentially that I've seen of the American public, doesn't matter what their ideological leaning is, doesn't matter what their race or ethnicity is, opposes race discrimination. Whether it's characterized as a preference for people or it's characterized as a negative, folks, I think, by and large, care that people be judged on their merit, judged on their character, and not on their skin color. There are a lot of reasons why polls come out that way, but I think that largely is the way the public views these types of issues. That's not to say, though, and this is important, this is what my organization, the Center for Equal Opportunity, tries to get out. The country, by and large, still is somewhat torn on what to do about equal opportunity for people in this country, about justice and fairness and how we achieve that. So you see, at the same time, folks say, they don't like racial preferences, they don't like racial discrimination. They're still in favor of programs like DEI programs that sometimes do discriminate, or at least risk discrimination on the basis of race or ethnicity. And so there's an opportunity that is open for persuasion of people who otherwise think there's something important to be done in terms of equal opportunity, but don't want the excesses of things like DEI and CRT and so forth, but think that there's something to that. There's something that can be done, that can be crafted right. Again, Rick and I were just talking about this at breakfast this morning. It's essentially not throwing out the diversity baby with the DEI bathwater at the same time. There's an opportunity. There really is an opportunity.
You have any response to that, Rick?
I think it's a good thing not to throw out the baby with the bathwater. I agree with that. I think I'll just say, this is a great conversation. I'll just add a little bit to Rennie's point about the geographic preferences, because I think they do represent what's really going to be the battle around higher education for the next many years, which is that of two different visions about what universities should be doing and what the criteria should be for selecting students. One vision is what we might call a meritocratic vision, right? The idea there is simply the role of the university is to select the best students, full stop. That's best, highest test scores, best grades, strongest academic qualifications. That's who the university should select. And that was kind of the theory underlying the plaintiff's claim in the Students for Fair Admissions case. But there's a different view, which I think the geographic preferences embody, which is that the universities, and we can call this maybe kind of a democratic sensibility, that the universities should spread the benefits of their education across the jurisdiction, right? And that was part of the motivation for what happened in Texas with the top 10% plan, is that there were lots of students at rural schools and inner city schools who would never make it to UT. And the idea was simply that if this is a state-supported institution by the taxpayers, it should serve all of the taxpayers. It should serve every region of the state. And I mean, that's plausible as well, right? And so we're really seeing a battle between those two visions. And we're going to see that as well with private institutions. At Princeton or Stanford or Harvard or somewhat, it is the case that there are, and in Stanford I actually happen to know the details on this, but the general idea is that a majority of schools in the nation will virtually never send an applicant to Harvard or to Stanford or to Princeton or Columbia or any of the Ivy League schools. Year after year after year, these schools bring in the majority of their applicants from what is in fact a fairly small number of schools, right? So you could also look at that and say, well, that's kind of a problem. These are institutions that, even though they're private, they are supported by all manner of indirect public funding and subsidy. Right, all sorts of tax expenditures and money that flows to them directly or indirectly. Yet they're only serving a sliver of the population who go to the same sliver of schools year after year after year. So maybe we could have something like a geographic program with private schools as well that would recognize that these schools should have some connection to a broader swath of the public. Right, and I'm not arguing for that. I'm just saying that that's a vision to contend with, right? The democratic vision on one hand versus the meritocratic vision on the other. And what we're going to witness over the next several years is these two are just going to be in battle in the courts, in the legislature, in public opinion, which will reflect the fact, of course, that if we think about both of those, we probably all feel a little conflicted or ambivalent about which principle should win out.
Well, I think that's a good way to address the broad question of how should universities reconcile their commitment to merit with also representation and balance. But I do think it's worth remembering that there was also a very specific question about racial discrimination that was addressed in the Students for Fair Admissions case. And that is that if you were an Asian student, even a working class one, in Houston, for example, your parents had come here without very much money. You worked hard your entire life, studied, and applied to UT or applied to Harvard. You had a much, much lower chance of being admitted. And that fundamentally was not only unfair as a principle, but also, the justices argued, illegal. That you had a right, particularly at public schools, but also at private schools for a variety of reasons, to be considered at the same level as your peers, sort of regardless of what the school's vision for racial balance must be. At a fundamental level, they argued that the Constitution prohibits denying that Asian student, and I use Asians as an example because in practice they were the ones who were most negatively affected, denying them of equal standing to be considered. And I wonder if you share that perspective on that narrow question. Do you think that as a constitutional principle that racial preferences that are explicit, that keep out people from high-performing groups should be illegal, and that basis of the ruling was correct?
Let me, this is a wonderful, wonderful question. Let me become even a little more provocative here, which is to bring in, I think I might be the only law professor here, so I'm going to bring a little legal framing to this. Within the law, sometimes you can recognize that something is unfair. Right, and in this case, I would agree, right? If the rule is that Universities should admit the highest achieving students, and they're taking into account things other than how high achieving you are. Yeah, that's unfair. That is unfair to that Asian American applicant who is not admitted in favor of a lower achieving student. So we can stipulate to that there can be unfairness, but here's the rub though, is that just because something is unfair does not mean it should be prohibited. In other words, let me repeat it again. Just because something is unfair does not mean it's not permissible. This is just standard black letter law, whether we are talking in the employment context or in the educational context. If you are an employee, say, who claims something happens that's unfair, you can get into court with that claim. But then if the employer can say, hold it, there's some overriding institutional interest we have in doing what we do, and that's why we did this thing that you claim is unfair. Because, I mean, this is part of the business plan of this corporation. It's why we make money, it's how we make money. If you can make that claim, the employee loses. So the claim of unfairness can get you in the court, but it doesn't win the case, right? And this is very much at play when we talk about legacy preferences, right? The Asian applicant could also say, look, my parents weren't legacies. The fact that you give the legacy students a preference to me, that's unfair. One way that could play out, and it's perfectly logical, is that the university can say it is unfair, and we're sorry it's unfair, but we have an overriding interest in admitting more legacy applicants, which is why we engage in this stuff that is admittedly unfair to you, right? And that's a tension, right? And the problem there is that we have individual claims and individual interests, but then they always have to butt up against the broader overriding interest of the institution, right? And this plays out whether we're talking about universities, whether we're talking about corporations, whether we're talking about the national interest. We always have these claims for fairness on one hand that are in tension with these claims for, you could think of them as claims for efficiency or claims for institutional goals on the other.
Well, I think that the distinction that Justice Roberts would draw and the other justices who ruled for the majority in that case would be that the Constitution explicitly prohibits racial discrimination. Things like legacy preferences or other tests that you might apply, those can be balanced against a meritocratic standard, but that there is a hard, explicit prohibition that comes from the Equal Protection Clause on this issue. And I wonder how both you, Renu, and you, Devin, would talk about the distinction in terms of why race is carved out as something that is unconstitutional in terms of universities' ability to discriminate.
Well, let me just say, and then I'll hand it off. This could be a much broader conversation. But the Constitution, if you really want to look at the text, it does not use the term race discrimination in the text at all. The term race, in connection with this, does not appear in the text at all. The provision that the Supreme Court relied on was the Equal Protection Clause of the 14th Amendment, which merely says equal protection shall not be denied. And the question is, well, what does equal protection mean? The Constitution doesn't answer that question. The justices have answered that question, but the Constitution itself does not answer that question, which again is why this is such a big fight, because we have this very vague sort of wording that people have to try to give some concrete meaning to.
Renu?
Rick, you've said so much. I'm thinking, okay, where do I start with everything? I think the notion of the point you make about just because something is unfair doesn't mean it's necessarily prohibited. And you spoke earlier in this conversation also about the interests of the university, and you used the phrase secret sauce, and who are we and who are the courts to infringe upon that. I think what's worth remembering is, you characterized SFFA as a group of Asian American students of various Asian origin groups coming together and saying, we have the highest test scores, we have the highest grades, we should be accepted. In fact, when you look at the original 100-something page complaint filed back in 2014, much of it was, Harvard's admissions officers are stereotyping us, and they are saying things such as, if an Asian applicant says, in his or her essay, I play a stringed instrument, we have too many of those. If you're told in high school, if you're Indian, don't write your essay about how you want to eventually go to medical school. Those stories were the cusp of the complaint, and was also brought in throughout, this 9-10 year long ordeal and litigation, were various college prep companies saying how they advise Asian students to hide anything that could be affiliated with stereotyping. So I don't think that it's just a matter of, this is unfair, but it's needed. I think what's worth considering is that you have a racial group of various ethnic origins in the US it's important to remember, this group has itself been victimized in the US. This was a key point in Justice Thomas's concurrence in SFFA, and he said, for example, Justice Jackson and Justice Sotomayor did not mention this history at all in talking about the victimization of racial minorities in the US. So I don't think it's just, schools are interested in this laudable goal of diversity and, various backgrounds intermingling and coming together. I think it's not just, you have the best test scores. That in and of itself is, sort of a racial stereotype against Asians. It's the notion that they were being Asian Americans were being sort of poked fun of, and that was the complaint, that why are we assumed to be one way when we are applying to Harvard? Why can't we write our essay about wanting to go to medical school for fear that an admissions officer is going to snicker at us and reject us, in spite of these other things that, according to the average, admission statistics at Harvard, would get us admitted. So I think that's important to remember. And again, the fact that it's an uncomfortable conversation. When you're looking at white victims, for example, it shouldn't be, but it's easier for many, particularly those of the political left, to say, well, we have a white victim, and whites historically in the US have discriminated against racial minorities, so they just have to deal with this. It is much more uncomfortable to take a Japanese student and say, you're a victim of this policy, when Japanese Americans have also historically been victimized in the US. So in that way, I think there's a lot of layers, and it's I think a bit more challenging than just this is unfair, but it should be permissible.
You have a last word for us, Doug?
I can be really quick. I agree with everything that Rainu just said, and to be fair to Rick, I think it actually is a difficult legal sort of question about what the Equal Protection Clause of the 14th Amendment actually means. Although, I certainly, if it's not already clear, side with Justice Thomas in his concurrence of what originalism actually demands of the 14th Amendment and what it actually means, and that is that it prohibits race discrimination, like what Harvard and UNC were doing for many, many years. But I mean, that's one of the reasons why I also like Title VI of the 1964 Civil Rights Act, which in concurrence, Justice Gorsuch wrote, race means race, and you can't discriminate on the basis of race. We could have decided this entire case just on Title VI. We didn't need to go to the Constitution. It's doubly prohibited, doubly wrong, the way in which the colleges and universities are doing this. The last thing that I really wanted to say, I wanted to tie Old Parkland Conference 1 to Old Parkland Conference 2 in my remarks and so forth. Boy, professor at Harvard Law, Randall Kennedy, I think said it best when he said, boy, we've spilled a lot of ink and paper talking about this affirmative action stuff, but what are we really talking about? Like the top echelon, very, very small sliver of elites in this country who are going to go to the most selective colleges and universities. That's not to say that it's not a real issue and not a real problem. But at the end of the day, affirmative action wasn't going to be the type of thing that was going to address the disparities that we see that fall along racial lines, socioeconomic disparities, which I think this conference, at least in part, and why I love it, and I'm glad to be back, is trying to get at. It wasn't going to pluck me as a poor black kid growing up in a single parent home in the South out of my situation and create opportunity for me. There are things in the pipeline that we really need to be addressing that I discussed in Old Parkland 1 that I hope that we'll have an opportunity to discuss maybe in Q&A and through the rest of this conference in an affirmative, positive civil rights agenda in this very historic time that we're in right now. Like we know we are. We really need to capture it and do something that I think is going to have a much bigger impact on Black Americans and other minorities in this country that are lagging behind than affirmative action did or could have ever done.
Well, thanks very much to the panel. We're going to open it up now to a question and answer session. So please raise your hand and we'll pass the microphone around. Let's start right over here.
Oh, you're going to hold it. Okay. So I want to pick up on a point that was just made, which is about, we're in this moment of political populism. And, Rick talked about how part of the special sauce in universities was giving them autonomy. But I think one of the reasons that a lot of people of different racial and ethnic backgrounds are looking at universities with a lot of skepticism. Look, I work in one. These are places that, fetishize elitism. They don't oftentimes lead to much social mobility. And I, sort of echo a little bit of what Roland was talking about last night. Just the parallel between Roland and the former president of his university. It's not as if these elite institutions have been making a deep effort to bring in disadvantaged minorities. And then the connection to K-12 from the panel this morning. Establishment civil rights organizations, the NAACP most famously, has been standing, opposed to schools like the one Ian's running, increasing the number of charter schools. So it seems to me, I'd like to hear the panelists talk a little bit about the disconnect between sort of our elites in society, especially in universities, and sort of the messaging here about, taking on some of what Roland said, like put your money where your mouth is, create some of these academies and actually try and get really disadvantaged kids to succeed in your institutions.
I think that's a fabulous point. And just to connect it with Devin's point, one of the reasons affirmative action at elite institutions doesn't solve societal problems is because it doesn't address the underlying issue that the creation of these universities represent, which is just such a scarcity of slots at the top. Which is to say, we have a system where we put the least resources in many different ways in the schools that serve the majority of students, and we put an enormous amount of resources in schools that serve very few students. And our system is more hierarchical, much more stratified, much more elitist, actually, than most systems elsewhere in the world, much more than in Canada, say, our neighbor to the north. And we also, I hope we actually can grapple with that maybe there's some way in which our elitist system is at odds with what we need education to be for American society.
In the back over here.
Oh, you got it, okay. So my question is, thank you for that great discussion, really to you, Rick, specifically. Early on, you were making an assertion about these private institutions that are unique around the world. Everyone wants to come here. And I wonder, the question is really, are these institutions really worth saving? Two things. I'm not sure that Harvard is as kind of market-based as you say. On the one hand, we talk about the legacy admits is really a lot about money. The second one is now we're learning that it's not really a marketplace of ideas, because there are sort of what we're hearing about is kind of these ideological kind of barriers where if you're on one side or the other of it, you can't speak your mind. So I'm wondering how much of a market institution it is, and how much of the government, as you say, these institutions are well funded by proxy by the government and also by student debt. Whether it is, and also we're seeing the market is beginning to speak about Harvard. We saw about the numbers of people applying and so forth. Is it really worth saving these institutions, and should we be looking, as we kind of ended the last panel with, at a newer system that's more of a free market system than this one that's a pretend free market system?
You raised a lot of big issues there, and I will say I think we need to do a lot. I'm on the board of the largest private nonprofit university in the United States, Southern New Hampshire University. We do extraordinary work, not with the students who would go to Stanford or Harvard, right? So we need more Southern New Hampshire universities and more the spirit and the impulse of that type of institution. So I agree with that. But I also feel a little bit defensive when you start talking about, is it worth saving them? And I would just pose the question, or actually make the statement, that without Stanford, there would be no Silicon Valley. Full stop. No Google, no Apple, no Yahoo, no, we can go on and on. Do you think that the technology that's been created in Silicon Valley has benefited the nation and the world? That would not exist if there had been no Stanford there, right? So yes, they're worth saving.
Right over here.
Excuse me. So this is a question for Rick. Rick, you getting all the questions this morning. Again, on institutional autonomy. So for context, in 2018, Harvard's Dean of Admissions said that in order to get a recruitment letter from the school, Black and Hispanic students needed to have a combined SAT score of 1,100, but Asian male students needed one of 1,380. Yep. So my question is this. Let's say we roll the clock forward 30 years, and the highest performing students in the country are Black and Hispanic. Black specifically, let's specify. What do you think the reaction, either from yourself, your colleagues, the media, would be if universities had similar plans that said a Black student had to score 200 points higher than his white or Asian counterpart in order to have a similar chance of admission?
We would all be outraged. We would be, that would be unfair. Full stop.
Anything more to add about how you reconcile that with your views on the issue?
Well, I think I'm very empathetic to, and I've talked with the people who have been involved in a lot of these litigations, including the Thomas Jefferson High School litigation, and their claims of unfairness are real, right? I mean, those are real. They should not be dismissed. But it is the case, though, that the fact that something is unfair as between individuals, that's kind of the first step in the argument or the analysis. But if you want to ask the question, is it justifiable from the societal point of view or from the institutional point of view? That's a lot more conversation there. And with universities, I will say, yes, there's a good argument. I'm also sympathetic to this argument that even though legacy preferences are unfair, even though affirmative action is unfair, if I were an institutional president, I would probably, or I could see myself being in support of both, even though they are both unfair. Now, that's just to say that, to put a point on it, take it back to the Silicon Valley example, what if it turns out that had Stanford never had legacy preferences, there would have been no Stanford as we know it, and hence no Silicon Valley as we know it? Is the unfairness of legacy preferences worth creating Silicon Valley? Yes. Would the unfairness of affirmative action be worth creating Silicon Valley? Yes. So it depends on what's the big thing you're trying to figure out or trying to move toward, and how do these arguably unfair practices help you to move toward them?
Over here.
This takes the discussion in a slightly different direction. The question is actually mainly for Renu. Do different Asian ethnic groups view race affirmative action differently? For instance, do Chinese Americans regard it more disfavorably than Indian Americans, or vice versa? And if so, what's the explanation? Any differences that you might observe?
Sure. So that's an excellent question, and in fact, very little research has been done on how various Asian origin groups view socially progressive policies such as affirmative action. In fact, there's one organization in the entire country, I wrote a report on them for MI back in February of last year, called AAPI Data, and they do polling on social issues of the 6 largest Asian origin groups in the US. The crux of the report was demonstrating through the political science, issue framing literature, how their polling questions want to elicit a favorable view of racial preferences in higher education. And so that's what they get amongst all Asian origin groups, except for Chinese Americans, even when they have an inherently biased question. In other work that Pew has done, dating back to the mid-2000s, for example, it appears that in terms of not just affirmative action, but many other socially progressive policies, Indian Americans are more in favor of those policies than Chinese Americans or Vietnamese Americans, for example. But again, the research is quite slim. In terms of affirmative action, the one Asian origin group in these few studies that have been shown to be vehemently against the policy are Chinese Americans. And you've also seen that, with our own eyes on the ground, a lot of Chinese American parent activists are leading the charge in California now for selective public high schools, the exam schools, and also the Harvard and UNC cases. But this is an issue that, Asians are now the fastest growing racial group in the US. And so the fact that there's just a handful of studies really trying to answer this question, what that means in terms of political mobilization and elections, what the parties can do to grow their voter bases, it really hasn't been studied. So that's a great question, and more research certainly needs to be done on it.
We have one more question in the front here.
Yay, I get a chance to ask a question. I'm wondering if we're not just, in some sense, talking in circles. Because, what is your definition of fair? Anytime all selection process is discriminatory, right? And there's an underlying assumption that somehow racial diversity is good. So what does that say about HBCUs? And is it because I got black skin, I'm bringing the same things to the table as anybody else with black skin? There's diversity within the community, right? So I heard Walter Williams once say, question even equal opportunity, where there is such a thing as equal opportunity. We know there's no such thing as equal outcomes. So, and then the idea about mismatched. Thomas Sowell talks about that, people being mismatched to the wrong type of colleges, where one college is teaching at a particularly really fast level. And if you get that there are many good students who sometimes end up going to the wrong colleges because they wanted to check the box. They say, okay, we got this number of black students, but they can't keep up. And they end up either failing out of the college, or they're getting poorer grades. And if they had gone to another school, they'd be getting straight A's. So I'm confused about so life is not, again, so it's not fair. Life is not fair. Not everyone can go to Ian Rowe run school or Catherine run school. Clearly at the lower levels, none of this is fair. Life just isn't fair. And I don't know how that can be a standard, or how you even talk about what that standard is if fair is going to be the standard. I don't know how this works.
Well, I just say, we can't, we need to talk about how we define fairness, but I think we would all agree that if the Warriors are playing the Mavericks and the refs have an agreement to only call fouls on the Mavericks and not call fouls on the Warriors, that's unfair. We would agree to that, right? So we would agree to that because we would have some agreement about what the rules of the game are. Right, so you always have to specify what the rules of the game are and what the underlying criteria for how it should operate, or how you should select students, what that should be. Now, in the higher education context, we were kind of supposing, just as a thought experiment, you could say, let's assume that the university's goal is to select the highest achieving students, which is a common intuition that we all have, is that if you have a bunch of students who apply and you can tell who the best students are, you pick the best students over the weaker students. And if you pick the weaker student because you say, that's my best friend's son, we would agree that's unfair. And it's the same sort of intuition that's at play. And again, these are hard issues, but that's a common intuition, which is a valid one.
I have an opportunity just to respond really quickly. I asked Coleman Hughes last night a question, two questions actually. I got enthusiastic about the opportunity. But I asked, look, if racial diversity plummets at schools as a result of the decision from last term, is that a good thing or is that a bad thing? Are we losing something? You suggested, Is your black skin sort of bringing something to the table? I think there is a real hesitancy to say, and I think it's right to be hesitant to say, all black people think alike, right? We're all the same, and you can just kind of plug and chug us, like that. That's certainly wrong. But I do think, I didn't hear Coleman respond in this way, and I've asked other folks since I've been here the same question. I do think that something is lost. And it's important to recognize the psychic injury that results from walking into a room and nobody else is black. There is a sort of a psychological element, particularly in a country that has the history that we have, and nobody in corporate leadership is black or Hispanic, whatever. So I'm concerned personally about the decrease which is expected in racial diversity. I'm not saying that we should use whatever means, such as race discrimination, to increase diversity on campuses or wherever else, but there's something that doesn't sit right with the spirit when, and I think other people feel this, whether or not anyone admits it, when you're in a fancy place or something like that and everyone serving you is black, but very few people who are eating are black. I think there's something to that, which is why I'm happy that the Supreme Court ruled the way it did. I think from a legal standpoint, obviously I've already expressed, I think that's right, but also shines a light on why the pipeline is problematic up to college admissions. And hopefully will, as I suggested, create right now in this historic moment, that positive civil rights agenda where it becomes less and less likely, not because of race affirmative action, but because people are actually the most qualified people to be in the room, to be on those corporate boards and so on and so forth, that it's not the case that you walk into a room and very few black and Hispanic people are there. Because we've fixed some of the foundational, fundamental issues of family, education, intervention, those sorts of things.
Well, thanks very much. Please join me in thanking the panel for the discussion.